Hi, everyone, and welcome back to another episode of the SCV Law and Life podcast. Today, we have attorney Lisa Golshani, who is a real estate, a, a trust and estate plan attorney, but she also does a lot of special needs trusts for family protection, which is not everybody does that. So I'm excited to have her here. Thank you, Lisa.
Thank you for having me, Mason.
Sure,
Good to
of
be
course.
here.
So let's start by please give us about a 2 minute background of about what you do and how you got here.
Sure. As you said, I'm an estate planning attorney. So what that means is I help individuals and families plan for, God forbid, incapacity or death
Hmm.
to ensure that their wishes are carried out, their loved ones are provided for and protected. Everything gets administered with the most privacy, least amount of cost, least amount of delays possible. So that translates into a lot of wills, trusts, powers of attorney, things of that nature. But basically, planning for the future, so that in case life throws you an unexpected curveball, you have your ducks in line and everything's in order.
Okay.
And I've been doing this for over 20 years. I have my own practice in Calabasas. And initially, I was a psychology major undergrad, and I wanted to be a counselor and counsel people. And then I ended up going to law school, and I thought, okay, well, estate planning is going to be a great bridge between the two of those because
Right.
there's a lot of counseling involved and law. So there's a kind of a nice overlap of the two, and that's how I kind of ended up in this field.
Yeah, I didn't know your undergraduate degree was in psychology because that's what mine is too, psychology.
Yeah,
Yeah.
yeah,
So,
very fascinating and fun stuff.
so for people who may not know, what's the difference between a trust and a will?
Well, a trust, the primary difference between a trust and a will is that when you execute a trust, it becomes effective immediately and it protects you during your lifetime. Whereas a will only becomes effective in the event of your death. Another significant difference is that a trust is it's a private document. So the terms of the trust are private unless you want to share them with anybody. No, the public isn't entitled access to it. Whereas when anybody passes away, a will is a
Mhm.
public document. It has to be recorded in the courthouse, and anybody can go to the courthouse and look. You can look up celebrity wills just by Googling online because it's a public document. So there's with wills, if you're passing your estate through a will, there's always going to be you have to go through the probate court, which is very cumbersome, very expensive, lots of delays. Whereas when you have a trust, whomever you've appointed as your successor trustee can step into your shoes, start managing your
Mhm.
assets and paying your bills and taking care of your affairs as soon as they can prove that you are either incapacitated or deceased. So there's a lot less delay. There's a lot less cost involved in the administration of a trust, and so those are the primary differences.
Differences. I'm really surprised to hear that a lot of the celebrities who passed in the past few years had neither one. I don't think Prince had one. Um, I know like a bunch of them who didn't have one.
Yeah, a lot of them don't have them, or they have outdated ones or incomplete ones, or so yeah, it's always shocking because everybody thinks they're invincible, and everybody puts this off oftentimes until it's too late. So it's one of those things that you don't realize how much you need it until something emergent comes up.
Yeah.
And then a lot of people will do their planning and then they won't look at it again. They'll put it on their shelf and say, okay, check, done. And years will go by and they figured that they've already addressed that. But unfortunately, like most things, estate planning does require maintenance because laws can change, your wishes can change, your assets can change. So periodically you got to review and maintain your plan and make sure that you're assets are titled properly, your trust is funded, because you could have a really great set of estate planning documents, but if your assets aren't owned in your trust, basically you have an ineffective, expensive stack of documents. So yes. So regardless of whether somebody has a modest estate or whether they're, a celebrity with a multi-million-dollar estate, everybody needs some type of planning.
Yeah. I think Aretha Franklin didn't have one either. I think that was another one.
Your memory is better than mine, I think.
So how often should, this is somebody who has a will or a trust, how often should they visit their attorney and look at it to make sure it's still updated?
There's no absolute rule, but the general rule of thumb is roughly every 3 to 5 years, or sooner if there's any kind of significant life change, such as a marriage, birth of a child, acquisition of a business, a significant increase or decrease in the value of your assets, change in family relationships, things like that. So whenever in doubt, I always think the best thing to do is to reach out to your attorney and check. Worst case scenario, they'll say you're in good shape and you'll be on your way. But sometimes little things can have big ramifications. So just periodically checking in and updating is important.
I mean, I know of situations where people get married and when they don't update their trust or their will, that their actual children don't get anything and they're left out, and it goes to somebody else who they have no relations to.
Exactly. If you don't update your plan, you could accidentally, leave your money could go to the wrong place, and you could inadvertently leave money to your ex-spouse or cut out your children, or so that's why it's so important, especially in blended family situations. That's even more significant. And we're having more and more blended family situations, right? So ensuring that you're providing fairly for the children from a prior marriage and your current spouse and maybe joint children that you have, that requires a lot of forethought, because if you just rely on the default rules, it oftentimes doesn't work. It works in a traditional family structure where the laws of intestacy will say usually everything goes to the surviving spouse and then equally between the children. But if the surviving spouse is a step parent, they don't have any obligation or duty to leave anything to your biological children that you had from a prior marriage. And unless they proactively plan on giving money to them, if a step parent dies, the stepchildren won't inherit anything. So it's really, really important to put a legal framework, not just have a verbal understanding of what your wishes are, but to make it legally enforceable.
So, you hear sometimes people say, well, I don't have anything to lose. I don't have a whole lot of money. I don't have a house. What do you tell to those people about estate planning?
Well, they may not need a trust. If they really, really have very insignificant assets, they may not need a trust. They may just need some basic plans, but basic documents. But regardless, even individuals who have no assets need a few foundational documents, such as a financial power of attorney, so that in the event of your incapacity, somebody you trust can make financial and legal decisions on your behalf. Another very important document is a advanced healthcare directive, where you appoint somebody to make medical decisions for you if you're unable to communicate for yourself, and where you state what your wishes are. And then another document that everybody needs is a HIPAA release form, stating that your healthcare agent and your financial agent and anybody else you want can have access to your confidential medical records. Because of privacy laws these days, and people are so worried about liability of sharing information, there's a lot of hospitals and medical facilities will not release information even to first degree relatives unless you have these kinds of documents on file. And I experienced that personally when I needed to access my brother's records when he ended up in the hospital. And initially they weren't going to even tell me if he was in the hospital or not. And then I remembered that I had him execute these documents. I sent it over, and then they allowed us to speak to his physicians and released his records to me. But without it, your family will be completely in the dark. That's why I have a lot of clients when their kids turn 18, the parents have their kids execute these documents, even if they have no assets, so that the parents can continue to have parental authority to step in and help in the event of an emergency.
I hope everything worked out with your brother. Everything okay?
Oh, that's a different story
Sorry.
for another day. I
Sorry.
wish I had a happy ending, but
Oh.
but what it did help my family a lot. My brother ended up passing away
I'm sorry.
7 years ago. Thank you. But what did help a lot was that we had these documents, and at the time we didn't know if there was any medical malpractice or not. So since I was able to get my hands on his complete medical records, we were able to go with a fine-tooth comb and evaluate exactly what happened. It helped us get some closure, and it helped us have our peace of mind. And we decided that there wasn't anything that we felt like we wanted to pursue. And while my brother was ill, it enabled my family and I to speak to his physicians on his behalf and help with his medical care. So, and honestly, before that happened to me, I didn't realize the importance of these documents. It's one of those things that until you personally have to use it, you don't recognize how important it is.
So how can people get a hold of you? As far as your office information, give us that, please.
Yeah. So my office number is 818-334-2805. And my website is www.golshanilaw.com, GOLSHANILAW.com.
Okay. So as I understand it, the medical directive is something that's not power of attorney document, something totally different, right? Because I know some people are going to say, well, I have a power of attorney. What do I need a directive for? Am I correct?
Correct. So the medical directive, I feel a sneeze coming on, but not quite.
Sorry.
The medical directive is for medical decision making, right? Who's in charge of healthcare decisions, what doctors you're going to see, what medications you're going to take, what kind of wishes you have in terms of prolonging your life, end of life decisions, that kind of a thing. A financial power of attorney, on the other hand, deals with financial and legal matters. Somebody being able to manage your IRA on your behalf, somebody being able to call the Social Security Administration and talk to them on your behalf. Somebody being able to manage your life insurance policy in the event of your incapacity, things like that. So they go hand in hand. So everybody should have really both. All adults should have both of them.
Okay. Now tell us about the special trust that you work on, because not everybody does that.
Yeah. So one of my passions is helping families that have children with disabilities plan for the future to just help ensure that they have a secure, bright future. And we do that. One of the legal vehicles we utilize to do that is a special needs trust. So a lot of parents invest a lot of time and energy advocating for their kids. And, we're really wearing multiple hats, serving as driver and advocate and nurse and, educational therapist, and doing so many things on behalf of their kids. And they worry about the future and what's going to happen when they're no longer there. And we are very fortunate that in California, there are a lot of services available for individuals that have developmental disabilities, but somebody still has to oversee those services and make sure that they're being implemented and provided properly. So there's a device that's called a third-party special needs trust where parents can establish these in advance, while they're living, for the benefit of their children. And when I say children, that could be for the benefit of their adult children as well. It's a way to leave an inheritance to your child so that it doesn't jeopardize that child's eligibility for needs-based public benefits. And also has a lot of other features. It's asset protected so that it would be very hard for anybody else to penetrate that trust in the event somebody wanted to abuse them or take advantage of them. And we can build in a system of advocacy. So the trust funds can be utilized to hire an advocate or surrogate parent type figure to manage all of these services and oversee the care of the child. And then you have a professional trustee managing the trust assets. And you can put in provisions for checks and balances in the trust too, so that there's we want to make sure that, again, nobody's neglecting or abusing their power. And one of the best ways we can do that is by making sure that there's, different people serving in different capacities and kind of checking on one another. So basically, through the special needs trust, it's kind of creating a vision of what the parent wants for the future of their child, what they envision, what their priorities are, where they want this child to live, who they want to have involved in their child's life. And it basically, whatever's in that trust can be used to supplement whatever the government's providing. So the government may provide certain resources, but they may not provide other resources. So for example, let's say the child wants to go on a vacation. The special needs trust funds can be used to pay for a vacation. Or let's say the disabled individual wants to have a companion. The trust could pay for a companion to keep the person company, or a caretaker, whatever the needs might be. But it's kind of like creating a private social service system to provide for the special needs individual. And when I say special needs, it's a very broad term. It could be individuals who are very severely impacted, and can't do anything on their own. They might be, physically and cognitively very disabled. Or it can also be sometimes individuals who are highly intelligent and highly capable, but occasionally have issues throughout their lifetime. It might be mental health issues, where there might be periods of their time where they're unable to work and look out for their own best interests. So, or it could be sometimes it's just somebody who doesn't really have a really good head on their shoulders, and just doesn't make the best decisions for themselves. So it's really a broad array of individuals who could benefit from this type of planning. But it gives the parents a great deal of peace of mind to know that there's a structure and there'll be continuity of care and oversight when they're no longer able to do it.
That's great. I mean, I know a lot of attorneys, and you're the only one that I know who does this.
Yeah, it's super rewarding. I love helping the families, and you really feel like you're going to be making a difference. So yes, but it's one of those things that's kind of a specialized area. So if you do want to pursue that kind of planning, you want to work with somebody who does have expertise and special training in that area.
Okay. Do you have an example of a family that you may have helped recently that you can share with us? It could be regular. It doesn't have to be special needs. It could be somebody who just came to your office, wanted to have the estate planning done. Just anything that would help tell people what your services can do for them.
Sure, and that can be so broad. But for example, it could be a family. It could be parents who are in their 50s and they have 3 kids, 2 kids that are in college and are doing great, and they might have one child who has Down syndrome, and that one child with Down syndrome requires around the clock supervision and care, and the parents don't want to burden their children with the entire responsibility of caring for their sibling throughout their life, right? They want the siblings to be able to have their own lives and pursue their own careers and not have that weighing on their shoulders. So through planning, we can put a structure in place to help alleviate the siblings of that burden by appointing professionals to serve in various capacities, where the siblings can just be an oversight and an advisor. But it helps ensure that they don't have to do all the heavy lifting. And by putting a structure in place, we can kind of foster a better relationship between the siblings, because the siblings can focus on being siblings rather than being financial managers and tax preparers and doing all the other types of roles that go into taking care of an individual with special needs, and or just administering a trust, right? Because even when you have a basic trust, it's a set of instructions that have to be implemented and carried out, and it's not a magic bullet. So somebody has to carry out those instructions. So by having everything properly laid out in advance, you can alleviate a lot of the burden from the family.
Is there a specific time in your life that you think somebody should start a trust, or it depends on the person?
So at 18, I think everybody needs to have some basic estate planning documents, right? A trust you want to start having, if you own real estate, it's a really good idea to have a trust. If you have minor children and you have any assets that you'll be leaving to them, you want to have a trust, because minor children can't inherit property outright. So let's say you have a life insurance policy and you name your minor child as a beneficiary and you pass away, then somebody has to go to probate court, open up a guardianship of the estate, and supervise the money through the court until age 18, and then it gets distributed in one lump sum with no strings attached, which nobody wants. So by establishing a trust, you can direct all of your assets, all of your policies in trust for the benefit of your kids. So if something happened prematurely, somebody you trust can oversee their inheritance for them. They don't get a premature, lump sum outright at age 18. You give them a chance to get established, get their career, get their education before they come into a large lump sum of money.
Okay. But yeah, so the basic estate planning would be the medical directive and the that's the kind of stuff you should have.
Financial power of attorney and healthcare directive. Yeah, but once you have any assets
of
any substance or real estate, then you want to have a trust. It depends on who your beneficiaries are too, right?
Okay.
If you have a minor child, if you're leaving money to a minor or to a special needs beneficiary, you definitely want to utilize a trust. If all of your beneficiaries are adults and you don't have any real estate and everybody has a good head on their shoulders and they can take their money outright, sometimes you don't need a trust. So for example, let's say we have an elderly person and they have $200,000 in their IRA account and they want to leave it 50-50 to their adult children who are, capable and independent. They can just name their children directly as beneficiaries of that IRA in general, and that would be fine. There's no need to utilize a trust in that scenario. So it depends what the asset is, who the beneficiaries are, and some other factors. But everybody should be, if you have any substantial assets, you should be consulting with an attorney to figure out what is the best way to structure things.
Yeah, so that's the best advice. Just talk to an attorney and give them all the information and they will walk through all of it. Yeah,
exactly.
So when you're not working, tell me your hobbies. What do you like to do?
I love to travel. So every opportunity I get, which is not as often as I would like, but now that my kids are getting a little older, I have 3 teenagers, I can get away a little bit more than I used to. So I love going abroad. I love visiting new places. My husband's a research scientist, so for his work he travels, and I love to just tag along with him and go places. One of my favorites was Switzerland. We went not this past summer but the prior summer, and just seeing the world.
Do you have a favorite place you've been to?
Lots. Italy was one of my favorites. Turkey I enjoyed a lot. I loved Switzerland. So any place that combines kind of historic history, architecture, archaeology, that kind of a thing, but also combine it with some natural beauty and water that you can seas of water that you can swim in, and that's my ideal. It's like the best of both.
Yeah, we went to Italy about 7 years ago. We went to the northern part, like Rome, Venice, Florence. Which part did you guys get to see?
We did the same things on our honeymoon. That was almost 25 years ago. Yeah. And then we went back to Italy and we were in Genoa for a little bit, but I want to go back and I want to go and see Sicily and then northern part. I want to go to Milan
Okay.
and see the Alps, the Italian Alps.
Got it. I have family in Milan.
Do you really? Yeah,
My mom's uncle has been living there for a very long time. So, yeah.
that's right. I've heard there's a little community there.
Yeah. Yeah, my mom wants to see Sicily and Calabria especially, so she wants to go to the southern part. Yeah.
Yeah, it's wonderful. It's so varied and so different. Every part has its own beauty. But I'm hoping, God willing, there'll be freedom in Iran, and next year I can visit Iran.
It's going to take some time, I think, before I feel comfortable about visiting. Yeah. Yeah. We'll see.
Well, we'll see. I think
Yeah.
things can change quickly.
Yeah, I know. So let me ask you a question. I asked this of all my guests. If you were to see your 10-year-old self, and based on what you know today, if you give her one advice, what would you do? What advice would you give her?
Just I would tell myself to believe in myself, and have confidence in myself. Not doubt myself. I mean, everybody fakes it till they make it to a certain extent, I think. And that I should feel confident in myself and feel good about myself. Okay. Not impose any limitations on myself.
Great advice. Can you please give us one more time how people can contact you?
Absolutely. The number is 818-334-2805, or you can email me, lisa@golshanilaw.com. That's LISA at GOLSHANILAW.com.
Okay. And your office is called Law Offices of Lisa Golshani?
That's correct.
Okay. All right. Well, thank you for being our guest today. And for everybody who's watching this, we hope you guys like this episode. And if you please like us and subscribe, and we'll see you on the next episode. Thank you so much.